Hello and welcome to the program. Ukraine's Justice Ministry has filed 6 lawsuits against Russia with the European Court of Human Rights. According to the head of the department, Pavlo Petrenko, they are related to the annexation of Crimea as well as massive violations of the rights of Ukrainians on the peninsula. Now, one of the lawsuits concerned the violations of the rights of 71 political prisoners illegally detained by the Kremlin. So how high are the chances to actually win these lawsuits? Joining us in the studio today to discuss this is Lishchyna. He's the Deputy Minister of Justice of Ukraine and the Commissioner for European Court of Human Rights. Hello, and thank you for joining us.
Hello.
So what is the situation as of today? Can you sum it up for the viewers?
Well, as of today, we did file 6 applications so far with the European Court of Human Rights. One of them was recalled at the request of the actual applicant. And some of them were disjoined and again joined. At the moment, we have 4 cases pending before the European Court of Human Rights, intergovernmental cases. The applications filed by Ukraine against Russia concerning violations of human rights. One of them concerns violations of human rights in Donbass related to the ongoing aggression in Donbass area. One of them concerns Crimea as a whole, basically all human rights violations that are taking place in Crimea during annexation and after that. And one additional case concerns children which were taken from Ukraine to Russia, but for no reason by insurgents in Donbass. So far we had 3, and last Friday we filed a new application which concerns 71 political prisoners. We basically consider that Russia violates their human rights and does it systematically and for the only reason of their political views. Basically, they are political prisoners, that is why. So basically, Russia says that they are criminal, terrorists, whoever.
Yeah, there's a classic rhetoric.
Yeah, but in reality, behind that, the actual reason is that they hold political views which Russia believes to be unwanted.
Now, these lawsuits adds up to the other, but what are the effective mean of the European Court of Human Rights? Because Russia is known to ignore, ignore international law, to ignore most of that kind of law. So what are the means of that kind of court?
European Court of Human Rights is an old organization which has a very extensive experience in making its judgments enforced. Of course, basically it is an organization which encompasses countries which are supposed to enforce those judgments without any additional pressure. But in reality, it is almost always a difficult task to do, even with democratic countries. Sometimes they need to change their legislation or do something else, which takes time, which takes political efforts. So basically, a European Court of Human Rights is well aware of difficulties related to the execution of the judgments. There is a specific body called Committee of Ministers of the European Court of the Council of Europe, which supervises the enforcement. So once the judgment is issued by the court, it goes to the Committee of Ministers, which requires from each state action plan, certain step plan. How are you going to enforce this judgment? So basically, there is already an existing institutional mechanism which forces country to follow those judgments. Of course, some countries are less democratic than the others, for instance, Turkey or Azerbaijan, and they might see the enforcement of judgments as somehow, infringement of their sovereignty.
And political tool from Europe.
But eventually all the judgments of the European Court of Human Rights are enforced, like all of them. For instance, there was a situation in the 70s when so-called black colonels in Greece came to power. They withdrew from the European Court of Human Rights. Greece withdrew from the European Court of Human Rights, from convention, and there were some judgments issued against Greece whilst it was outside the convention. But still, in the end of the day, they rejoined the Council of Europe and enforced all the judgments which were issued in the meantime. So basically, historically, I have no doubt that all the judgments of the European Court of Human Rights would be enforced. Of course, it would take time, it would take efforts.
And that's an interesting point that you're raising, because these 71 political prisoners detained by the Kremlin, there are some, and speaking of which, Oleg Sentsov, and they don't necessarily have that time for that enforcement.
Well, it's always the thing with the European Court of Human Rights. It takes time to come to its judgments. However, in cases which the European Court might consider to be of utmost importance, where the life of the applicant is at risk, European Court of Human Rights can use the enhanced procedure, which is like abridged, like it takes less time, and we believe that in this particular case, it is the case which the European Court who should consider within this faster procedure. And we did file the relevant application with the court. I'm not sure how the court would react to that, but still we are doing our best to speed up the consideration.
So once there's a judgment done, once, let's say, Russia potentially is condemned to that, what's the result after that? What's the next step after that? And can it result into sanctions? What's happening after? The judgment could be used in many ways. The most obvious and straightforward manner is to basically enforce it through the Committee of Ministers, as I described. And that enforcement might include the release of the persons concerned. We know the situation with a political prisoner Mamedov in Azerbaijan, who was released recently. Yes, it took several years for the Committee of Ministers to persuade Azerbaijan to release him, but still for Azerbaijan it was a very big step forward. So in this situation, if we are successful, and I believe we should be, then European the Committee of Ministers would press Russia to release those who would still be imprisoned at the time of the issuance of the judgment. So basically, I think that there is no doubt that eventually all of those prisoners would be released. So that's a direct result of the judgment. Of course, politically it could be used in various agendas. For instance, it could be used as a reason for further sanctions of the EU, for instance, or US or whatever. But that would not be like the logical extension of the legal nature of the judgment. Now, that's the sixth lawsuit, and obviously I think that I have the feeling that this European Court of Human Rights have a lot of lawsuits, to deal with. Doesn't the multiplication of lawsuits against Russia could it be counterproductive at one point, or do you put priority on certain lawsuits?
Well, it could be counterproductive, and at some point we felt that because Ukraine filed the first application in 2014, and it concerned only Crimea, because, well, it was the time of Crimea annexation. Then when aggression in Donbass commenced in April, Ukraine added further complaints with respect to Donbass to the original case, but European Court of Human Rights disjoined this case into two, Crimea and Donbass, respectively. Then the new application was filed with respect to events of 2015, again concerning Crimea and Donbass, and then again European Court of Human Rights disjoined them. And so at some point we had basically four cases which concerned
more or less the same situation.
Well, basically it's the same situation, yes. We asked the court to join them in one case or in two cases, for instance, one big case on Crimea and one on Donbass. The court did not react for some period of time. Then we realized why this was so, because they were preparing to transfer the case to the Grand Chamber of the European Court of Human Rights. So once the Grand Chamber assumed jurisdiction, it almost immediately followed our advice and joined those cases together, because at some point Russian Federation started to argue, let's consider this case and postpone that one.
And put, like,
so
basically use time to postpone the cases. Fortunately, the situation was resolved and in correct, as we believe, manner. This new application, the situation is a little bit different. It was difficult to join it to any of the already existing cases. That is why we filed a separate case, because it concerns the situation with Ukrainians, for instance, in Russia, in mainland Russia, where there is no question of control, effective control, as there is a situation with Donbass, where Russia says we don't have any effective control at all. And the situation with the Ukrainian prisoners taken in Russia, it doesn't raise this question. It's a different situation, a different set of facts. That is why we filed a separate case. And on top of that, this case not rising difficult jurisdictional issues, does rise difficult factual issues and requires an enhanced. Which are, for example, can you develop?
No, the whole, the whole case with respect to political prisoners. It doesn't raise jurisdictional issues, because I mean, Russia would not say that Russian territory is not controlled by Russia. Well, that would be stupid. So basically, they would accept that the court has jurisdiction to review those cases. But Russia would probably say that all those people, they are criminals, and so. It would require a lot of factual work for us to prove that actually those people are political prisoners, not criminal ones. And
so you're saying the angle is different here?
The angle legally different and factually different. And on top of that, it requires faster examination than all the other cases. Okay. So that is why I think that it was the correct thing to do, to file a separate application. So
when will you have the potential answer? Do you know more or less what's going to happen?
Well, first the court would have to open the proceedings, would have to assign a certain number to the case and start a communication between the parties. For instance, providing Russia with the opportunity to comment on our application. So I believe that, well, that would be would have to be done within like a span of maybe a week.
Now, do you plan to file all the lawsuits, or so far? Because that's surely going to be other cases, and we see every day other cases of violations of human rights. So do you plan to file all the lawsuits, or like so far you only plan to concentrate on these ones?
Probably we're not going to file any new applications. What we are going to do, what we are planning to do this autumn, probably like this fall, we are going to file additional information on Russia's control over Donbass in 2015, well, up to now, basically. So we filed a very extensive material with respect to 2014, like the beginning of aggression, and factually it is the most difficult part of time to prove Russia's control, because, well, basically it was all those gangs there, they were controlled by Russia, but they were fighting against each other, so the question of control is difficult. After like in 2015, when Russia introduced this system of Army Corps 1, Army Corps 2, basically creating an institutional system for this for this so-called army, it's much easier to show the Russia's control here. And well, we're going to do that. We're going to produce those documents. We are going to file a new complaint within the big Crimean case with respect to exclusion of Ukrainians from Crimea. What Russia said when it annexed Crimea, it said, we're not going to disturb you, like continue living. Everybody who has a residence in Crimea, Ukrainians, they automatically become Russian citizens. But if you don't want to become Russian citizen, you can go to Migration Service, file a relevant application, and retain your Ukrainian citizenship, and we're not going to disturb you. In reality, what happened?
It didn't happen.
I mean, people went, they refused from Russian citizenship, and now Russia starts to send them away, saying that you violate the regime of the stay in the Russian Federation because you are foreign citizen. So they're doing that, and that is a very similar violation to that which was found with respect to the same actions of Russian Federation during the Georgian War. Because in 2008 they did absolutely the same thing with Georgians, but they did it in mass, and it was very obvious and easy to prove.
So, if there's a pattern here in Georgia, in the Georgia region of Ossetia, Abkhazia, and if there's a pattern there in Crimea, is it possible to link the two cases?
Absolutely, that's exactly what we're going to do. There are two Georgian cases. Georgia versus Russia 1. There is already a judgment, and it concerns the mass exclusion of Georgians from Russia. There is a violation of convention found against Russia. And there is Georgia versus Russia 2, which concerns a human rights violation during the aggression in Ossetia and in northern Georgia during the war of 2008. There is no judgment at the moment. Recently there was a hearing, and we're expecting the judgment to be issued by the end of this year. And of course, for us, it is a very important judgment because it would basically show the Kurds' attitude towards very similar issues, not the same issues. Russia did not deny using its official forces there in Georgia, unlike in Donbass, where they basically say we're not there. But still, the issues are very similar, and it would be very important for us to review. We are going to the whole my office watched the debate in the hearing because they were recorded and put on YouTube, and now we're expecting the judgment.
Well, we'll also closely follow the case. Well, thank you for this overview. It was a pleasure to have you in the studio today. That was Ivan Lishchyna, his Deputy Minister of Justice of Ukraine and the Commissioner for European Court of Human Rights. Thank you for watching UATV. Stay tuned for more.